The following is a legal advertisement from Gwendolyn J. Stirk and the Family Law Group. This does not constitute legal advice and should not be construed as such. This podcast is for informational and educational purposes only.
Hi, my name's Reagan Freitag, and I'm an attorney with the Gwendolyn J. Stirk Family Law Group.
And I'm Gwen Stirk here, and today we want to have a conversation about when you can get a no-contact order, which is kind of a unique situation that I think a lot of people don't know about. Wouldn't you agree?
I definitely agree. I think people tend to think that they always use the word restraining order, and I think they mix that up when it's civil or criminal or family. I think they get confused about that.
Right, and you call the police, there's been an incident in your home and there's been domestic violence, and that's really an order of protection. But today we're talking about something a little different, a little unique, which is a no-contact order. Correct,
and I think people need to understand the difference, if it's a family relationship, if it's a friend, if it's a neighbor, if it's a friend of a friend, and I think that's where we need to define that for people.
Right, so an order of protection is going to require that familial context or even a boyfriend-girlfriend relationship, something more than just an acquaintance or a passerby.
And isn't it somebody that it's also if they live together too, right?
Sure. If they live together, then they can get an order of protection under that portion of the statute. But if you think about those incidences, and it's true of a lot of people, they've had unwanted sexual contact or advances made by someone that are inappropriate. There may not be enough evidence to be able to put this to the level of getting a criminal charge pending, and they need to have a remedy. So the state of Illinois tried to address that.
And even issues at work, harassment from sexual harassment at work. I mean, there doesn't have to be a sexual act, but it can get pretty close at work sometimes for people.
That's correct. And people don't know that there's a remedy. And I think that the issue also is that people don't understand, and nor does the police department understand, that this is an available additional remedy. Because if you think about it, when you go to criminal court, the standard of proof is much higher.
Absolutely. But what's great is a lot of these police officers have been trained where they know that, okay, fine, they can't make that arrest, and they don't have enough information to bring the state's attorney, but they have been trained to leave these individuals with information on how to obtain these orders, which is really good.
Right, and then when you understand that process, what you can do is you can go on your own, and basically it's a civil remedy. So let's first talk about the level of proof, because I think that's where people have the most significant opportunity here to get a remedy.
And it's different. In criminal, it's beyond a reasonable doubt. So in civil and no contact order, how is beyond a reasonable doubt different than the standard that you'd need to get in this situation, Gwen?
Well, in this situation, would you only have to have preponderance of the evidence? So, for example, if you're going to allege that somebody had inappropriate sexual contact with you, and you only have yourself and the person who was involved with you, you're not going to get to that standard of beyond a reasonable doubt unless there's some kind of corroborating evidence. And so this is different. This is simply an allegation saying this happened, and the judge can listen to the testimony, determine by the preponderance of the evidence whether or not it happened or didn't happen, and if they believe that there's been enough evidence put forward, give you the remedy of that no contact order.
Preponderance, it's kind of a big word. How would you explain that to people?
Yeah, it is a big word, but I think preponderance is that more likely than not it happened. Not that you can prove it beyond a reasonable doubt, that there would be no exclusion of it happening, but simply saying that this is a credible story. I believe that it happened. I believe that this person is saying the truth to me. And remember, that's why we have judges. You go back to who's going to make the decision and who's going to make the call, and I'm always saying to people, a judge is like, remember the biblical story of Solomon. Because in that biblical story, Solomon had the baby in front, and two mothers were contesting, well, who is this baby really belong to? And when they were going to cut that baby in half, then we knew who it belonged to. It's the same concept of a judge. When the judge is hearing those two stories from two individuals, they're going to determine, based upon the evidence that's put before them, in their opinion, was it more likely than not that it happened? Do they believe that it reaches the standard of preponderance of the evidence, and then give the remedy?
I think that's so much more reassuring to people, knowing that they can go in and they can tell their story, and that, criminal is scary, but that they, if they have enough information, they can tell this judge this, and they'll listen to their story, or you hate to say story, what happened. And these people need to realize too that judges are people, and they're going to use their own instance or experiences and listen to them and look at their evidence, and it's not as scary as criminal.
Right, and in addition to that, it's also what would a reasonable person, so you're talking about the experience of the judge. So remember, it's what a reasonable person would determine to be an unwanted contact or an unwanted sexual advance. It's not just simply because I don't like to be touched, and so if you touch my arm, therefore I think you've made an inappropriate sexual advance to me. That's not what we're talking about. We're talking about what would a reasonable person, meaning an average member of the community, deem to be an unwanted advance.
And I think what people need to also realize is when they go to court, yes, it's scary, and that's our justice system. You take it serious, but they need to know that. Feel comfortable. What I always tell my clients is tell the truth, and your honesty and your demeanor and your body language, that is going to show the judge that this in fact happened. They're going to see the fear. They're going to see it's okay to cry. Be truthful and honest when you're in front of this judge.
Absolutely. And the other thing that you have to realize is that if you're going to go for this no contact order, the first time you go to court, you're going to meet with generally a domestic advocate who's going to help you draft the petition to put before the court, and the court's going to hear it on what we call an ex parte basis. And that would be on your own without notice to the other side. But due process does require that there be a return date on that.
Correct. And you're able to go to court by yourself and not have to give the other person notice, because this is a scary situation. And if you give that other person notice right away, that requires time. And these orders of protection and or no stalking order, no contact order, these need to happen now. And these are emergencies.
Right, they're real-time emergencies. Now, that's not to say that somebody doesn't have the due process right. So if you are on the other side of this, which, we're speaking to both parties here, not just the person who obtains it, but also the person who has to defend against it. If you get a no contact order, first of all, and first and foremost, obey that order till you can go back before the court, tell the court your side of the story if you're the one defending against it, and then the court will make a determination whether or not this order will be long-term or not.
I like how you said, first of all, obey that order. Second, call Gwen. You need to call your attorney, because the return date may be 2 weeks later. Well, guess what? You can get in, and you should be able to get into court a lot earlier than 2 weeks, because this can affect your family, your children, where you're living, your work, your ability to carry a gun. I mean, there's a lot of rights here that can be taken away for 2 weeks, and 2 weeks is a long time.
And so you get in and you do those things, and you have an opportunity to respond. And yes, and that's really where I want to end up on this, is basically the conclusion is if this order is entered against you and you have a no contact order and you have to be with this person at a work environment, a school environment, wherever that may be, there's going to have to be accommodations. And for example, if a school gets involved, the school will have to make special accommodations to ensure that there is no contact. And remember that the no contact also extends that you can't cause a third party to then have contact with that individual either. And I think that's a real tricky issue, because that's where people try to skirt around the issue.
And third party just doesn't mean, oh, my friend is calling this other person. It doesn't have to be a person. Third party communication is Facebook, Snapchat, Twitter. That is third party contact. So if you try to skirt the issue, like you said, it's not just through a person, it's through social media nowadays.
Right, and if you violate these orders, then you can look at additional criminal charges from that. So we're talking today about civil no contact orders. So if you've been the victim of inappropriate sexual contact that you believe that a reasonable person would find to be offensive to you, you should contact an attorney, understand your rights, and take action immediately with regard to it, because there is help.
Yes, there is, and we are here for you, and we will help you understand if you have any other questions.
The proceeding was a legal advertisement from Gwendolyn J. Stirk and the Family Law Group.